Thanks, David. So we have a lot of exciting ground to cover today, and I'm excited to get into it. But I did want to say I did speak with all of our panelists, and if you have questions, please feel free to interrupt us and ask those questions. Of course, a discussion is always great, and we love to talk class actions, as you'll soon find out. So maybe I'll start with you, Sarah, and just, I guess, to level set and see where we are. Can you maybe speak to the volume of class actions being filed across the country and perhaps a bit of the regional breakdown and the types of claims that we've been seeing?
Yeah, sure. Happy to do that. So as I expect everyone in the room knows, class actions are litigated here in Canada, typically in the provincial, superior provincial courts of each province. Increasingly, we're seeing class actions in the federal court, but of course, those are limited to matters within the jurisdiction of the federal court. So still a bit of a niche area. And as anyone who's touched class action practice knows, the question of where plaintiffs choose to file their cases, whether those cases are proposed on behalf of a national class or just a provincial class or residents of some but not all provinces, and whether there are overlapping cases in other jurisdictions is a real mug's game. And we don't have a coordinated way of streamlining those cases when they do overlap. There have been various attempts at that over time, but no real satisfactory mechanism to do that for defendants. So as those of you who have dealt with class actions will know, that creates a rather frustrating situation and a confusing assortment of overlapping cases often for defendants, and they require some real strategic coordination across provinces. And so, you know, we spend some time trying to figure out where plaintiffs are filing their cases and why. And so I thought I would start to answer the questions, though, with just giving you some numbers. These are taken from the Canadian Bar Association's National Class Action Database, which is meant to be comprehensive and that folks are required to report their filings. But, you know, there may be some discrepancies in terms of timing in the numbers. If you can't see it too clearly, Quebec will not surprise you to know that Quebec is the orange line with the nearly vertical line between 2024 and 2025 on the right-hand side of the chart. Ontario is gray and BC is black. And sorry if those are a bit hard to distinguish. So I guess a couple of trends I wanted to point out from this slide. The first one, which many of you will be aware of, is we really have seen a move west with class action plaintiffs choosing BC over Ontario as a venue for proposed national class actions. And you'll see from the data that there's kind of been some jostling in the recent years between them. And it looks at present, based on the most up-to-date numbers that we have, that the number of filings as of kind of mid-2024 was almost even between Ontario and BC. So it sort of looked like Ontario was recovering some ground, but certainly many, many more filings than we were seeing in BC in the earlier class action days. So in the midpoint of this chart around 2016, you'll see there was, well, 2014 even, huge difference, many more in Ontario than BC, and then BC has sort of steadily picked up steam as a more attractive venue. So, and then Quebec, sort of fairly steady up and down increases, a drop at one point, but then just a massive increase in recent years. So I guess a couple of thoughts about why the move west. One theory, and of course we don't live inside the heads of plaintiff class action lawyers, but we do spend some time trying to figure this out. One driver is a perception that the fairly recent changes to the Ontario Class Proceedings Act might make it more difficult to certify cases in Ontario. And so I think there was a period certainly where plaintiffs were more reluctant to file their national class actions here on the theory that it was going to be harder to certify the cases. And we'll come back a bit later to whether that has actually played out in the case law or not, but certainly that was the perception. And certainly the hope on the defense side was that this new test in the changes to the statute would have some more teeth and give defendants some more tools to oppose certification. Another driver is the question of whether a given province has an opt-in or opt-out model for extra provincial residents. And BC, so the gray provinces here are all now on an opt-out model, which Ontario has been in since its inception. But BC flipped from an opt-in model, which are the few remaining red on the Atlantic side provinces. BC was an opt-in model where extra provincial residents had to choose to opt in to a class action in BC. And in 2018, I think they changed that, which obviously made it a much more attractive jurisdiction for plaintiffs to file proposed national class actions. So that's certainly a factor. The next map shows costs regimes. In Ontario, as you know, we have a loser pays cost system in general, and in particular that applies to certification motions. And some of our law here has created some not insignificant risk for plaintiffs who go all in on extremely complex class actions and are not successful in getting them certified. There are all kinds of examples, but we had a proposed privacy class action against a financial institution that we fought on just a pleadings basis. So we were only in the first part of the certification test. So it was really a very big glorified pleadings motion that was extremely hard fought on both sides. And the cost award arising from that motion was over $1 million. And so that kind of cost award is something that creates real risk for plaintiffs, making them shy away from Ontario. And then conversely, you'll see BC in red has a no-cost system at certification. So if you're a plaintiff lawyer trying to figure out where to start your claim, BC you may have an easier time getting your claim certified, and you don't have this threat of a big cost award if you're unsuccessful. So a couple of theories on that front. The Quebec rise, and again, we'll come back to Quebec in a bit more detail later. Those of us who don't practice in Quebec are always a little bit reluctant to talk about Quebec, but it is a bit of an elephant in the room. It is, as many of you will know, like a hotbed of class action activity. The number of claims are huge. Cases are extremely readily authorized as compared to certification in Quebec. It appears in some cases to really just be a rubber stamp almost. The process also welcomes far less input from defendants in terms of evidence. And so increasingly we're seeing not only these increased filings, but just a real lack of tools in the defendant's toolbox to oppose certification, which they call authorization. I guess the one other factor that I think is driving some of this activity, and then I'll stop, is just, the plaintiff's bar is entrepreneurial. They're always looking for new types of claims to file, but they also seem to be looking for new practice areas. So where regulatory or other changes in their jurisdiction make their current practice, say personal injury in BC, less attractive, or some other part of their work has dried up, class actions seems to be a very attractive area. So we've seen a lot of firms who previously maybe only practiced in individual litigation, really taking on class action claims. And then some BC firms even opening Quebec offices so that they can then start a national claim plus a Quebec claim themselves.
Thanks, Sarah. Yeah, and I guess, this combination of the opt-outs, the no costs, and the Ontario change in legislation has really started pushing people west and east. And I'm curious, David, moving on to you, if you could maybe speak to whether that's consistent with your experience being in-house, if you've seen that shift as well.
Generally, yes. We've definitely seen more cases in BC of late. I think most, if not all, of these BC cases become national cases, with Quebec cases being enveloped in them. We find that Quebec cases are filed independently, and if they're not many of them get wrapped up into national claims, but when they're not, they're beast on their own. We have to deal with them separately. But we are seeing a lot of Quebec-only cases that are progressing forward. I think I'm a little biased, but I seem to, from my perspective, they seem to be more novel cases, maybe testing the waters. Now that's my perspective. I'm sure the class counsel don't think that. They think they're perfectly authorized, cases that should be authorized. We've had some successes in challenging authorization and have won at least one or two cases at authorizations, which was a nice surprise, not a surprise. I think those were cases that really didn't merit authorization, and it wasn't just a rubber stamp. So from our in-house department, we were glad to see that. It's not always, often it is though. I think they represent in Quebec maybe perhaps more risk than if they were filed. Those cases in Quebec, they would represent more risk than if they were filed in BC or Ontario. In terms of volume of cases, now this is my Hyundai experience over the years. You know, when I first arrived at or first started working at Hyundai, I would see one or two cases that would have to manage at the same time. I think right now we have between 5 and 10 class actions that we're managing at the same time, which is really, you know, all hands on deck for those one or two. And now we have a lot more that we're dealing with, which is a trend that I don't know if that's an automotive sector trend or if we're being swept into the general trend of increased volume of class actions. And then in terms of subject matter, obviously, because of the nature of Hyundai's business, we see more product cases, but we are seeing some non-product cases like advertising cases, challenges to insurance products that are being sold at dealerships. Those are some of the cases that we have not always seen come to fruition, more novel cases. I think also I've observed that some of the class actions that we've been named in are tracking national discourse in the country as well. We've had cases in Quebec that deal with, but we were able to extricate ourselves from that case, but dealing with operations and practices at dealers during COVID or advertising in Quebec, as well as allegations of certain technologies not deterring theft of vehicles as much as they should be. At least that's the allegation. So those are sort of national discourse topics that Hyundai as a company has been swept in terms of class action. So the trends in jurisdiction and subject matter and volume mimic what Sarah was saying, but we're also seeing things that are unique to the automotive industry and dealing with those issues as well.
Thanks. That's interesting. And you know, I want to pick up on one of the things you said, which is just this trend that you're starting to see different cases, including marketing and advertising style cases. And maybe Tony, I can bring you in here because you know, one of the things that we often see with class actions is it is kind of you see new emerging trends and litigation trends start in the class action space. So I was wondering if perhaps you could speak to emerging trends that you're seeing. And obviously David's seeing something that crosses with your space. I'm curious as to what you've been seeing, not only in your space, but I guess more broadly as well.
Well, I only focus on competition, but it happens to be coincidentally that's where a lot of the new claims are coming. So it's a very exciting time for nerds like me who pay attention to these things. But I think that as a foundational point, we've had over the past 2 to 3 years pretty significant amendments to our Competition Act. We haven't had amendments like this since the Competition Act in its modern form was created in the mid-'80s. So it really is a different act than the way it used to be. And we're starting to see now some of the ramifications of that. You probably have heard, I'm happy to talk to you about changes to our competition tribunal that are creating a private class action regime there. But also what's happened is that there have been, given substantive changes to the law, new kinds of competition / consumer protection related claims that are being brought. So you may have noticed that there are a lot more pricing and advertising claims that being brought. This concept of drip pricing, where like a faucet drip, 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 where you don't know what the full price of the product is at the outset, but you may learn of it in a subsequent click or two. So that has really developed. Like I fun fact, prosecuted the first drip pricing case back in 2015 for the Bureau. And that was under a general provision where the onus lied on the Bureau to prove all elements. With the amendments now, they deem the practice of drip pricing to be a false and misleading representation. What that drip pricing is actually a matter of debate, but the point is that with that deeming provision, it's a lot easier for plaintiffs to make the case that a claim is false or misleading. You're also seeing different kinds of advertising claims about, pricing, whether a sale is a fake sale or a real sale, and just sort of different permutations. And greenwashing, you probably heard a lot about this, hasn't taken off a bit as hot as we thought it would be as of the amendments in June of 2025, but we're starting to see remnants of potential claims arising out of that. And you're seeing different regulatory authorities getting involved, not just competition, but at the securities level. And the thought is that that will lead to subsequent class action activity. So I think there's a lot going on there. The other big trend, I would say, broadly speaking, is AI-related litigation. I'll borrow Zoe's intellect in a moment because he's had some experience with this, but in the competition space, you're seeing a lot of AI-generated algorithmic collusion type of theories of harm. We've had a historic low of international cartel activity. This is the kind of stuff where, like in the 90s and early 2000s, the parts of your car or electronic components were all alleged to have been subject to a price fixing conspiracy, and lots of public guilty pleas and investigations, which subsequently led to lots of class actions. We're on a low right now. Some would say it's because of good compliance. Some would say we can talk about that. But the point being is plaintiffs are a lot more creative now in trying to find new claims that are not necessarily subject to public enforcement. And one of those is sort of these AI-based claims where you might have a central depository of a third party who's collecting information and as a result of that, and then distributing that information in some aggregated or anonymized way to others. But some are challenging that. For example, there's a larger rent fixing conspiracy going on right now where a central depository sort of has benchmarks that are used then which people will then use to then set what the rent ought to be. And people are challenging that algorithm or method as saying, calling it an indirect way to price fix. And we're starting to see other areas where this AI, there's a case in Europe involving tires that came to North America involving earnings reports and AI generation of multiple competitors' earnings reports to somehow come up with what the price ought to be. And that's the theory of harm being alleged in this case. So really nuanced, different kinds of cases related to AI, but there's also a copyright element to this.
Yeah, and I can speak very briefly to that. I'm not a copyright lawyer, but one of the things that we have seen starting to pop up on the class action side and also just generally in the litigation side with this intersection with AI are copyright class actions, which is something that you didn't really see a whole lot of back, 10, 15 years ago. But the central allegation in some of these proposed class actions is effectively that some of these companies that are creating these AI models are using copyrighted material to essentially create the learning system for these AI models so that they can then spit out these original AI creations that are allegedly based on copyrighted material. So there are these copyright claims for input infringement, and there's also output infringement claims, but I think input infringement is the big part of it, where you're allegedly using these copyrighted materials to train your AI model. So that's something we've been seeing. And of course, I think the other trend that we'll probably see in the AI space, and we've already seen it in the social media space, I'd say, is this intersection between technology and product liability, where there are allegations. Obviously with the social media company, there's a lot of ongoing litigation right now with respect to effectively product liability negligence allegations that these tools are harming youth and the school board claims and everything else. And I think in the AI side, especially now that AI is starting to open up and there's more interactions with it, and you're reading these stories in the paper about people having fairly negative experiences, and I think that's something that I would guess might be something you'll see in the AI side as well in the coming years, but that's a to be determined, I guess, for now. But definitely a lot of litigation kind of popping up in that space. And maybe if we take it from trends more to the results of some of the claims that we've been seeing to date, and perhaps Vera can bring you in here as to, what are the trends that you're seeing in terms of what's being certified and what's not being certified? Can you perhaps speak to that over the last little while?
Yeah, and I think it's interesting because I think all this talk about sort of novel claims, and I think you're quite right when you observe, you're seeing some plaintiffs kind of trying to be creative with claims and what they're bringing forward. And I think what I'd like to focus on in talking about kind of what we're seeing in the cases, it relates to that because there's basically from the perspective of evidence and pleadings, we're seeing the courts really taking a gatekeeping role in some cases, emboldened by decisions that have done some good work in establishing that that's the kind of work that we ought to be doing in certification, which I think was often a question, for courts, like how rigorously should we be looking at these issues at this juncture. And so I think there's some really good opportunities to resist certification by focusing on, well, what is this claim? Is it a real thing? That's not a legal term, but is this a thing that you can say? And what's the evidence for it? So I'll just focus on those two topics for a couple of minutes. So looking at evidence. So now, we've had this big debate in the case law about is it a two-part commonality test? Just to put it in plain language, what the courts have now pretty broadly accepted, and we had Court of Appeal, confirmation of this last year in Ontario, the federal court a couple of years ago confirmed, that's the case for federal court, is that the plaintiff can't just give evidence of there being common issues. Think of a class action as being, okay, you need some issues that are going to be the same for all the people in your class. The plaintiff also has to have evidence that the issue is a thing, right? That there is some issue that something to demonstrate that there isn't a defect in the automobile or the drug causes some kind of an illness. You can't just assert it. And so the courts are denying cases where the evidence isn't there. And so that is a really significant opportunity to look at, well, is this something the plaintiff just dreamed up and wants to take a shot at proving at trial, or, more realistically settling before you ever get there, like most cases, not just class actions, or is it something that has some legs? And so the standard is very low. So it's the some basis in fact is the standard, meaning just something. But interestingly, that has some teeth. And so a couple of things that I put up there on the slide in terms of the kinds of things that the courts are saying, no, this is not enough, are claims that are speculative. So really you don't really have evidence that's, a common area where this might come up is there's some parallel US case, and you see this all the time. It starts in the US and then a plaintiff will bring a case here, and it's really based on what the allegations there are, maybe based on investigations that happen there. And there may not be a really real connection to the class that the plaintiff has brought forward for certification in Canada, or any evidence that this is an issue that actually impacts that class and ought to be adjudicated. And so the courts say that that's not sufficient, and you can have a claim denied on that basis. Another area where the courts have been saying, no, this is not enough, is cases where the evidence really shows just a risk of harm. And I shouldn't talk about this because the Zohaib here has the leading Ontario Court of Appeal case on this issue from last year, where the court very helpfully confirmed that the potential risk of physical harm in the future is not a sufficient basis for a claim, and that's not sufficient evidence to allow a class action to be certified. So in that case, it related to the use of drugs containing what was an alleged carcinogen, but the plaintiffs didn't have symptoms or illness. The claim was really for an increased risk of cancer in the future. So the court really looked at this, and so, can speak a lot to this in detail if anybody's interested, but the court looked at this and said, that's not sufficient. That kind of claim and that kind of evidence doesn't pass muster even on our low test. And that also has to do with, the substantive law about what's compensable loss. But there's a very interesting example of something where you might look at this and say, well, what are you claiming about, and what kind of evidence can you bring forward? It might not be sufficient. The courts will also look at whether, where you need scientific support, do you have that? Is this based on, again, something speculative, where there isn't really something to show that there is a link of the kind that you're alleging? And, there's various examples of cases, but, there's a case involving talc powder and allegations that it causes cancer. And the court in the first instance told the plaintiff, you don't have enough evidence. You have to bring us something saying that there is a real link here. The court, not to overstate it in the sense that the court is not going to weigh evidence. It's not supposed to typically. does try to stay away from this. So it's not about deciding, and I think that's always the tension, right? I mean, that the plaintiff doesn't have to prove their claim, but they do have to have something, and it has to be, the other point I would make here is that it has to be admissible evidence. And so we're also seeing the courts, as they're looking at these cases as a gatekeeper, looking at the evidence that the plaintiff is relying on and having to do that for purposes of this part of the commonality test, and saying, this isn't admissible evidence. This is, triple hearsay reports. You can't rely on this report that was used in some other process for some other purpose to establish as the sole fact that establishes a basis for the claim that you want to bring forward here. And I've seen some more rigorous looking at hearsay issues and admissibility of experts by the courts in these cases, which I think is another way in which you can sort of look at your case and consider, okay, well, we might have a few different avenues to really attack the case that the plaintiff is bringing forward by looking at the evidence and what's required, despite the always low standard. So that's on the evidence front. And the other thing I would emphasize is pleadings. So, and I've maybe done this backwards because they come first, but the courts are doing their gatekeeping work here. I mean, the case that Sarah mentioned for the financial institution that we worked on, so we struck the entire multi-$100 billion claim with 18 causes of action on the pleadings. So that's the court looking at every single cause of action and asking, is this a weird thing that the plaintiff has made up? And does it work? So a couple of different ways you can go about it. One is to look at, have they even pled the elements? So, if this is an intentional tort, so we see this all the time in privacy class actions, because the privacy torts are intentional, negligence is not. So the plaintiffs, if they want to get at some of the benefits of proving loss more easily under the privacy torts, will plead them. But you have to plead intentionality, and you have to say the words, but also kind of have to make sense in that context. So if you're saying, this maybe gets into too much sort of detail for the time that we have, but if you have the intrusion upon seclusion tort was the big one that the plaintiffs were trying to bring forward, where there was a hack. Like if your company gets hacked by an outside attacker, you can have a negligence claim, like, did you have proper systems because you prevented this? But the claim was that the company intruded on the privacy, on the seclusion of the folks whose information was affected. And so there was a big debate in these cases about whether that's the kind of intentionality that the tort requires. And so we litigated those issues in the case Sarah mentioned, and another case, which led to the appellate court authority that establishes that no, that tort is not available as against companies who get hacked by an outside party, because there isn't an intention to violate the privacy of the people whose information it's holding. So that's really significant because it has implications for the scope of liability. It has implications for your exposure. And so even if the case proceeds with different causes of action, knocking out something like that can really alter the landscape of what that litigation looks like, of the prospects for exposure, for resolution, for all sorts of things. And that's, I'm out of the gate looking at how has the plaintiff pled this case. And there has been a lot of sort of novelty in the pleadings, the plaintiffs, as the law evolves. And for example, this decision on this tort has spawned different approaches in the last couple of years, with plaintiffs are trying to find different ways of getting at these easier methods of getting compensation for people who are affected, because you don't have to prove loss in the same way as you would for negligence. And so now we're seeing new things being brought forward. And so we're looking at these claims again with an eye to, okay, have you pled this properly? And also, is it a thing that makes sense in this context? So there's a lot of opportunity there to be really strategic, to really analyze those, and a real potential for narrowing the class and narrowing exposure very early.
Thanks, Vera. And yeah, there's definitely been that trend focusing on loss, I think, both on the pleading side and the evidence side, to zone it and say, have you actually pleaded some compensable loss here? You see that a lot in the product liability side where I practice, but I think across many different causes of action, loss is often an element of that cause of action. So defendants have had quite a bit of success targeting loss, both as Vera mentioned, on pleadings and evidence. And, you know, one of the other things that brought a lot of hope to defendants, particularly in Ontario, was when we had our amendments. So I was wondering, maybe Sarah, you could speak to
Yep.
whether that hope has actually helped defendants, as I think a lot of defendants thought the new amendments to the Class Proceedings Act would really help them in Ontario.
Yeah, so the high level answer is maybe, although less hopeful and still waiting to hear. So we really haven't had cases yet in the meaty areas where we hoped the court would really grapple with this new standard. And there are some in the pipeline, and so there is still some hope in that regard, but really kind of TBD. So I'll unpack that a little bit. This first slide, just so we're all on the same page, gives a bit of detail on what I want to talk about as kind of the most important 2020 amendment to the Class Proceedings Act, which was to change our predominance standard to make it closer to what US lawyers are used to in the federal class action legislation in the US, to introduce both a predominance requirement that the common issues have to predominate over the individual issues, and a superiority requirement that the class proceeding has to be superior to all other avenues for pursuing these claims. The Ontario government undertook a big consultation before making these changes and heard from lots of different stakeholders. And there was a bit of surprise and controversy when the revisions to the statute were spit out and included this, hopeful for defendants new requirement that looked a lot like the US system. And I think there was hope in a couple of areas in particular, where in the US certification of for example, a products liability case that had a personal injury component would be a total non-starter. But here in Ontario and in BC, many of those cases would be certified. They'd still go through the certification test, but we were seeing cases in those areas get certified. And a few other areas, I think it gave some hope as well, where, we in Ontario were seeing cases certified that wouldn't get through the test in the US. So the first main case to look at and apply this new preferable procedure standard in Ontario was a decision of Justice Perel, who's now retired, which is probably bad news for defendants, in a case called Banman in Ontario. And that was a case involving patients who'd been treated in a forensic psychiatric unit of an Ontario hospital. And they were claiming breaches of fiduciary duty, negligence, vicarious liability, a whole sort of kitchen sink of things. And Justice Perel, walked us through an analysis of this new preferable procedure standard and then ultimately certified the case. So the two big takeaways from his analysis are that this new standard is meant to be a stricter test. It is meant to raise the threshold for certification. He used the words heighten the barrier, make more rigorous the preferable procedure criterion. And he talked a lot about the need to weigh the common issues and what would be decided in common issues versus what would be left over to deal with in individual issues, and a real kind of balancing of those two, which all sounds very good and hopeful. But then he did the thing where he said that nevertheless, notwithstanding this new stricter test, the certification judge needs to put the whole case through the lens of the goals of class proceeding legislation in Ontario. So judicial economy, behavior modification, and access to justice. And in my view, that introduced an element of real analytical uncertainty to what otherwise seemed like a stricter test, where you were doing this balancing between what's common, what needs to be dealt with individually, and does this make sense? Now you have this further layer on top of it, which seems to suggest, and I'm obviously not doing justice to His Honor's reasons, but that seems to suggest, well, if there really is a case here and there really isn't another way for these class members to bring their case forward efficiently, then on balance, once you put it through this lens of the goals of access to justice, behavior modification, and judicial economy, this really still does make sense anyway. And so this analysis has been cited in a couple of other decisions. There really is no appellate authority on the point yet. So that's another maybe glimmer of hope. And there haven't been any applications of it in a products case with a personal injury element, or in the context of some of the employment class actions that we have. And so there are cases in the pipeline in all of these areas. I think we'll see decisions in the next year or so that may or may not follow Justice Perel's analysis to a T, and they may or may not then end up before the Court of Appeal. So it's the analysis doesn't leave us all that hopeful at present, but there's still a lot yet to be determined.
Thanks, Sarah. I want to maybe shift gears a little bit now and talk about how often what we will find in the class action space is defendants who are faced with not only a class action, but also concurrent regulatory proceedings. And Tony, I know that's something that you've seen particularly in the competition antitrust space. So I was wondering if you could perhaps speak a little bit to, what the approach is in situations like that, where you've got these concurrent class proceedings and regulatory proceedings. And I'm sure there are a lot of concerns with mixing the two, but they're both going on at the same time. So there's some things you can't even avoid.
Well, there's a couple of ways to approach that. So I would say that in the battle days of international cartels, you would wait for some form of an investigation in Canada or in the United States. And if you sought immunity or leniency in the United States, say you would go and do so in Canada. Why not? That's no longer the case right now. We have had a historic low of leniency markers even in Canada. And so the bases upon which plaintiffs bring cases has varied. So you're starting to see a lot more activity of regulatory investigations in Europe, for example. Even though the cartel test is a little different, you'll see it in some form of a preliminary investigation in Europe or elsewhere, and that will lead to class actions in Canada. So that's a bit of a change and a departure from the way it used to be. The other thing I would say is that the Competition Bureau, like when you're negotiating something with them, it's always been the case that you have to think through how you negotiate with them, because what kind of impact that will have on the class action. So if you're negotiating a guilty plea about a product or something like that, the relevant period of time, the product inputs you're talking about, you've really got to think that through in terms of what could happen if we sort of admit to that here. That's also happening in the consumer protection space. So if you're entering into negotiations with the Competition Bureau on a consent agreement, which is basically when you settle with the Bureau, you have to register the agreement with the Competition Tribunal, and it takes the form of a court order. So there's no such thing as a private settlement with them. And so when you're doing that, you really have to think through each provision and what kind of impact that will have on the class action. But the new dynamic, I would say, is also being introduced now is the opposite trend, where you're actually seeing class actions being commenced first. And you have to actually think about, when you're defending that, what kind of impact that might have on the regulator. I can tell you from my time at the Bureau, we get everybody gets press clippings every day. And so they get clippings of every sort of development involving their space. And that would include new cases that are filed and press releases from plaintiff firms. And when you're thinking about considerations arising out of a class action, perhaps changing the conduct or perhaps, filing that piece of evidence, you actually have to think about, okay, what would the Competition Bureau do with this subsequently? So there's that dynamic now where the class action is first and perhaps the regulatory investigation is to follow. So that's another trend that we're noticing these days.
I guess sticking with that idea of having multiple proceedings, regulatory and civil, I'm actually also curious, and maybe Vera, you could speak to this, because what we often see is multi-jurisdictional class actions, where you've got multiple class actions in multiple jurisdictions, and oftentimes they will be proceeding in tandem. So I'm wondering, Vera, if you can maybe speak to the coordination of multi-jurisdictional claims and how you approach global claims.
Sure. Well, I'm going to direct you to the title of the next slide, which is quote from a decision where a court was looking at what might happen given what was going on in that case with these overlapping multi-jurisdictional claims, potential for chaos and confusion. So that was the sort of situation then. This is a bit of an older case. It still is in many ways, although we've brought some order to it a bit better, I think, than we used to have. As many of you may know, I mean, this issue arises, as Sarah said earlier on, from the fact that we don't really have a mechanism to consolidate or manage these cases in Canada, other than at the level at which they have been brought. So in the province where they have been brought or the territory where they've been brought. And so you have to, in order to get rid of one case, you have to deal with each of them in each of their respective jurisdictions. And then you have the mechanism to get rid of one is to convince the court in one of the jurisdictions to either stay their own case or to refuse to certify it. The court can't tell if you have concurrent BC and Ontario cases, you can't have the BC court tell Ontario, oh, you should not let your case proceed. So the couple of implications from that, I mean, one is you have to deal with it in each court. And then secondly, there's going to be some coordination that has to happen between sometimes plaintiffs as well, if they're thinking, strategically about it, but certainly from your perspective as a defendant, from a company's perspective as a defendant in one of these cases, that coordination of your strategy across the different jurisdictions is critical. And there's no real playbook for this in the sense that the rules are not, there's no rule that says, here's how we deal with cases across jurisdictions through this sort of supra provincial system. I alluded to having some more systems. We now have these multi-jurisdictional protocols that lawyers and judges worked on over the years to try to allow for some of this coordination in a better way. And they've been incorporated into the rules of the class actions procedure in the different provinces. So we see some of that through those rules, but you're still really dealing with it on a province by province basis. And so the strategy around do you prefer one jurisdiction over another? So let's say so just the basic question. So you have a Quebec case, you have a BC case, you have an Ontario case. What do you want to do? Like, what would be the best thing to do? So what's the issue? Is it a privacy case? What's the law in Quebec on privacy? What's the law in BC on privacy? Is it a national class? Do you have people who might be affected, who might be subject to the BC law if they're BC residents, even though the class also includes Ontario residents who would not be subject to the BC statutes, but would be subject to the common law as it relates to those claims? Where would it be best for those issues to be heard, do you think? So just a sample of the kinds of questions that you'd want to be asking yourself. What about timing? How quickly is this going to move forward? Who's the plaintiff counsel? It's a kind of it's not a legal question, but that you might care about that. And then, even if you have, eventually have a view on these issues, then the question is, well, what can you do about it? So as a defendant, and, my colleagues have alluded to this challenge already, as a defendant, what can you do to steer a case to sort of develop more in one jurisdiction over another? Sometimes, generally your options are limited, that you can't just say, well, I pick this one and we should just move forward here. But you can do lots of things to try to steer things in that direction, to try to enable one of those cases, to support one of those cases to proceed. Sometimes the timing is more important. Sometimes because of these multi-jurisdictional protocols that are in place, plaintiffs from other cases can come to speak at the certification hearings in another province. They must be notified. So the BC plaintiff has to tell his Ontario competition, hey, I've got a case here and it's going to certification. And if you have something to say about it, you should come. And they might come. And you may be able to take certain steps that will increase the chances that the case that you think would be best to proceed first or best to proceed only actually has the opportunity to do that. In terms of the mechanisms, this is not new, but the mechanisms are some kind of an abusive process application. It's not necessarily an abusive process. I remember thinking this, to me, when I first started thinking about these issues, I thought, well, surely it's an abuse. No, it's not. The court says, well, there might lots of reasons why you might have concurrent claims. So I want to think about, might this be one of those that is an abusive process? And then is another case the preferable procedure? So this is where it kind of becomes interesting, because you might want to say, yeah, that case is preferable and it should be happening there. Even though normally you're resisting the idea that anything is preferable. And then there are jurisdiction questions, as we have a forum non-convenience argument, that sort of thing. But really considering, especially all of the complexity that we've been talking about, and when we're seeing these kind of novel claims and these new approaches, and thinking about what's in the pleading, coming back to our defense strategies before. What's in your Quebec pleading? What's in your BC pleading? What's in your Ontario pleading? Which one is vulnerable on the law that's going to be applied in relation to those claims? What's the plaintiff's evidence? So, and then really stacking those up and looking at them as a whole. I mean, we work as a team with our colleagues across the country. So, we're working together with our BC colleagues, with our Quebec colleagues, Alberta colleagues, and looking at this every step of the way in terms of what the status is of each of these cases. And what the potential, what the likely trajectories, where is this likely to go? And then what are the potential ways in which we can bring some of our strategy to bear on what the plaintiffs are, trying to simultaneously push on us across the country. So this is where, you have a lot of creative thinking. You can kind of really have some creative strategies that really benefit from the experience of seeing how these things play out, because of that lack of a real playbook for this, and seeing what's happened in different cases and how courts have reacted and how plaintiffs handle them in different plaintiff class action firms can really be a benefit. So it's a bit crazy, but it can be kind of fun for, as Tony said, for us class action geeks.
I guess one of the things I'd add is the only time you see these different provincial courts get together and coordinate is when a case settles. And that's when you'll see the courts come together, and you'll see these hearings where we'll have one court on one screen, another one on another, and you'll be sitting in another, and they'll all start coordinating. And it's a few times you see them get together. And on that topic of settlement, David, maybe I can bring you in and ask you kind of more from a strategy perspective. Can you speak, I guess, from your perspective as to when you're likely to take a case to certification, and when you're likely to start to approach settlement and engage in early settlement discussions? And on the point of settlement, I know when we had spoken earlier, you had some really interesting insights when it came to settlement administration as well. So perhaps you could speak to that too, because I'm sure there's a lot of people here who would love to hear about that.
Sure. And when Vera was going through her comments on certifications, and she was saying, well, you got to figure out whether there's something here. Is this an actual thing that's going to happen? And is it not just a risk or whatever? And then what are the chances on certification? And I think what your executive teams are looking for is like a crystal ball. It's like, are you going to be able to tell us what's going to happen or not? And I think that decision of whether to enter into early settlement negotiations or discussions, or push to have class counsel tested at certification, is really an exercise for in-house counsel, at least, in assessing what are the business's objectives in handling that case, with its sensitivities to the subject matter and all these things, as well as balancing the risk of taking one side or the other. And I think engaging in those assessments, it's easy to say that, but engaging in that assessment, I think, is not exactly straightforward. And I think my following remarks are going to be maybe obvious to those of you that maybe have been managing these cases for a long time, but hopefully there are some tidbits that I can give you from my time in dealing with many class actions over the years. And from my perspective, I think within the company that you're working in, the nexus of all the relevant factors or perspectives and considerations in assessing whether to go forward with a case or not, or just to devise a strategy is really with the in-house counsel. And I think recognizing that particular fact, I think it's a fact, is the first step. And I think it's a great opportunity for in-house counsel to make a real impact and on the company, and to influence the direction of where the company is going, and really to show the ability of in-house counsel to make well-reasoned business decisions for the company. So for example, as in-house counsel, I found that it's really essential for you to first start with what's the local company's goals, sensitivities, and general perspective on a case. If there's a recall, you would think maybe that, well, if there's a recall, there's a defect. And so we've already gone out to the public and said there's a defect, so we might as well settle this case, but not always. You have to overlay other perspectives like local counsel, external counsel's perspective, and maybe, yes, there's a recall, but the way that the plaintiff's counsel has organized this class action and the way that they've claimed it is not ripe for a class action. Because yes, you have a particular issue, but involving all these other OEMs, we call them, other manufacturers, may not be an appropriate step. I think also the next thing that you have to also look at, and well, Hyundai is a global company, multinational company. And so there's obviously going to be a global direction on this particular issue. Hopefully there is. And so what's the global perspective? What's their experience been? What is their strategy in dealing with this case? And you have to acknowledge and account for that perspective as well. And usually the most relevant experience is the US experience. And so sometimes at Hyundai, we've been the trailblazers, and that's not always a comfortable position to be in. But often we're coming after a class actions that starts in the US. So strategies taken there, experiences with evidence, sensitivities in the US make a huge impact in Canada. And as I mentioned, all those perspectives need to then be considered within the context of the Canadian law. So the Canadian context, considering nuances and procedural steps that need to be taken, nuances in the law and how things can progress in Canada. I think being able to take all those considerations and perspectives and being able to present a thoughtful proposal to devise a local strategy it's also not only just essential to be able to have success in Canada, but it enables you to really demonstrate your ability to make impactful decisions and recommendations that really benefit the company from a global perspective as well. I mean, we don't report into the US, we report into above country in Korea, and but they're managing you. And so all that coordination, I think, becomes important for your recognition in the company. And maybe that's more of a practice kind of thing, practical career advice maybe. But I think it also, that's a sort of result of the work that is done up front to make sure that, yes, the right decision is being made. I mean, we've had for every point that Vera was making on those, I was going through my Rolodex of like, oh, we were successful in Quebec on that, but not successful in Alberta on that. And we made the same argument here. And so it is a bit of a crystal ball, but I think you make the best decision you can going forward. And I think along the lines of making sure that you have all the different perspectives, I mentioned the Canadian law and advice that you get from Canadian counsel. I think being able to navigate all those different stakeholders and all those different interests, you need to have retained external counsel like Fasken's, for example, that are sensitive to those realities. You have to know that external counsel really needs to know that you have people that you have to report to in Korea, from my perspective, from my examples, Korea or the US or Germany or wherever you have people, stakeholders in there, and they have to be able to build their workflow, their work product, and their advice to take into account those realities. If they're not on the same page, if they're operating a little bit, oh, I'm just going to report to Canada, they don't take that into account, that really creates inefficiencies in the whole process. On claims administration, I've seen very large class actions being administered very differently at Hyundai. And I think the piece of advice that I could give on that is making sure that you enter into discussions early with the people that you have to get things from. at the company, from whom you have to get things from. So I think that data, it's very data driven now. So people, the claims administrator has to know, have you already compensated this customer? Has this customer already filed a small claims court case or some other kind of case? And so gathering that data is is a difficult task to begin with, but also it's not part of the individual that you're looking for that data from. That's not their part of the job. Their objectives don't have, or their goals don't have help legal with this class action. Theirs are sell as many cars as you can. So, you know, you're really asking them to deviate away from their focus and helping you. And so that's important for you to find, as in-house counsel, efficient ways to help them help you. And just a simple thing where instead of having a download, some of our systems are, well, none of our systems are made for legal processes. So downloading data that we want in a certain way is sometimes difficult. But we've had success in training claims administrators on our systems in a read-only way, so they can go in there as if we were asking our own people and find a way to get at that data real time in their system and not extracting data, because that's inefficient. It also reduces time of manipulating, or not manipulating, but processing that data at the claims administration company. And so, you know, those are the kind of the strategies that we've tried to implement to try to make the process as painful as possible in the business. But I think that also what we find is that because we have customers seeing old clippings or making new allegations, thinking that they're in a group of a previous issue or making connections where there are no connections, having resources at hand for previous, current, and future class actions is really, really efficient for the team members to be able to take those calls and speak intelligently to customers. That's more of again, a more practical perspective on what our company has to deal with on a day-to-day basis. But I think having those resources handy limits the back and forth that you'll have with the business unit, asking like, what's this? What is this class action? And so thinking of those things up front and having them with the tools that they need to deal with customer complaints or customer inquiries, or for us, for Hyundai dealer inquiries as well. So those might seem obvious to some of you, but I think those are some of the things that if I was looking back, you know, 5 or 10 years, that I think those would be helpful tidbits going forward for me.
That's very helpful advice, both for in-house and external counsel. I know we're running just slightly over time, but there's one final topic I just wanted to very quickly touch on. And it is, as Sarah mentioned earlier, the elephant in the room, and it's a rather large elephant to the east of us, which I sometimes like to call the Wild West, but maybe it's the Wild East. And that is Quebec. You know, we're all as common law lawyers in Ontario, we're all very hesitant. We're happy to talk about BC, Alberta, and Saskatchewan, and everywhere else in the common law provinces. Quebec is a whole different story, and you know, we are sometimes reluctant to talk about Quebec, but I'll pick on you, Sarah,
Sure.
if you want to maybe just share, you know, some insights into what we're seeing in Quebec, and maybe I know you've spoken to some of our Quebec colleagues, so
Yeah.
maybe you could tell us what they've been saying.
I'll be quick and high level about this. You saw from that earlier slide, this huge increase in number of filings in Quebec. So that's one trend. And part of the reason for that is their authorization test, not certification, is a lower bar. And so plaintiff lawyers in Quebec are filing cases because they can get them authorized. The Court of Appeal is contributing to that by overturning decisions dismissing authorization. That has now happened in a couple of instances that are adding to the fire, lowering the bar for authorization further. And then added on top of that, there also seems to be some concerning case law on punitive damages. One case in particular where the Court of Appeal made a very significant award of, I think it was $10 million in punitive damages against a defendant in a class action, without there even being an underlying compensatory damages award. So when you think about that, that's, you know, concerning on a number of levels. And again, just fueling this Quebec plaintiff lawyer fire. I guess the flip side of those trends that we're seeing in terms of how defendants manage this, there's a lot of strategy that goes into these considerations, including what proceedings in other jurisdictions are you dealing with at what time. But there is some strategy around strategic consent to authorization, particularly in Quebec, but also in Ontario and other jurisdictions. Can you leverage the possibility of consent to certification or authorization to narrow an otherwise unmanageable claim and, you know, avoid some cost of certification and achieve, you know, a more manageable case that then might be settled, or if you have a strong case on the merits, taken to trial. And then further to that, one trend we've noticed is that not all of the lawyers hanging out their shingle and practicing class action law as plaintiffs lawyers in Quebec or here really enjoy taking cases to trial ultimately. So certification is, you know, been the main battleground for so long, but sometimes just getting to the merits is a good thing for defendants, because plaintiffs may realize they're not really up for the fight or the volume of documents, or this don't have the skill or experience that it might take to take a case to trial. So there's, you know, unique considerations in every case, and looking at who the counsel are that you're dealing with and any number of other things, including, again, the whole span of cases you're looking at, both in the US and Canada, and now the prospect of class actions in Europe popping up. So there's lots in the mix, but you know, we are seeing class action cases go to trial here as well with some success. We've had some in our office. And so we can't forget as class action defense lawyers that that's a strategy too. And sometimes you find out that plaintiffs aren't particularly keen on that. And so there's lots of room for strategy there in an otherwise very dark picture for defendants in Quebec.
Thanks, Sarah. So that wraps up our panel. I'd like to first thank all of our panelists, and especially David. Thank you for coming out and joining us. And thank you all for attending. We can take a couple of questions if anybody does have any questions. So maybe I'll pause to see. No. Oh. Yeah.
Thank you very much. That was incredibly informative. I've been challenged lately, and I'd love to hear some thoughts on some creative ways of settling that you might have seen, or whether, thank you. And whether I've heard murmurs of backlash, perhaps, in certain ways of structuring it, where, let's say, I'll throw numbers out there, you're settling for 5 million, but let's say it's 3 million cash, but you're paying plaintiff's counsel fees based on a 5 million amount, and you're dealing with the balance. And how creative have you, and this was in Quebec, I caveat that, how creative have you seen some of these settlements being structured?
David, do you want to, I don't know how your experience has been, but as somebody in-house, I'm curious as to whether you have any insight there.
We have tried to make, if we have a settlement in the US, for instance, we do take that settlement as a guide, but we don't necessarily replicate it. And in doing that, there is some creativity that we're building in. So for instance, an example would be, if it's in US dollars, we just take that absolute amount and call it Canadian dollars. So that's, I don't know if that's creative or not, but it's a reality of what we've done before. We've also tried to, there have been benefits for the customer where we've encouraged them to come to the dealership, for instance. So we'll give a voucher for a service voucher. So yes, that's money in the customer's pocket, but that does, it does bring the customer back to the brand, as well as, you know, if your car was subject to this issue and you had to sell it at a loss, then we'll give you a rebate on a new car, or we'll, you know, those kind of things. So we've tried to implement those kind of things where, you know, back in the olden day, this old case, we gave gas cards, not gas cards. Yeah, it was gas cards. Well, it happened to be a fuel efficiency advertising issue. So it made sense for us to give a gas card, but you had to go to the dealership to load it back in the old days. You can just do it online. So those are the kind of things that we think of to try to, we're not trying to, trick a customer to come in, but we are trying to make the experience better with the brand and to try to find those kind of compensations. Those are the things that come to mind. Yeah.
I'm happy to chime in. I mean, there are lots of different settlement structures that probably don't have time to get into, but one tool that has been quite useful is kind of bucketing a settlement amount into a couple of different pots. One that creates some certainty for plaintiff counsel in terms of fees that they might get and might involve certainty around, and I'm thinking of a device case, but certainty for provincial health insurers who are in the mix and want to make sure they're getting a certain recovery. And then perhaps smaller payments to other peripheral class members who might be Family Law Act claimants. And then another bucket that is a claims made bucket that your client only ends up paying when people file claims with the proof that's required for a given category of claim. And, often those categories of claims are pretty carefully negotiated in advance and help the defendant to get the amount down, and certainly give US counsel who might be managing companion cases some comfort that the amounts that may be paid out in a publicly disclosed settlement in Canada are not going to compromise what they're trying to settle individual non-class action cases for in the US context. And so that's one tool that we use, or we're trying to use to ring fence the total liability, ensure that you're not agreeing to a large amount and end up paying out really significant amounts to individual claimants, because the number of people that come forward are not what plaintiff counsel purport to be. So, but there's a lot of strategy and maneuvering in the settlement discussion to get to that point and to get some certainty around how many people are likely to come forward. But it's almost always less than plaintiff counsel tell you what it is.
And Vera, did you have something to add?
I think mine was really related to that same kind of idea. So, but I agree, the buckets are a good tool. And I think the only other thing I'd add is it touches on this kind of awkward thing in class actions, which is this idea of like who is actually affected and who's going to come forward, and the tension in this humongous procedure and this huge case and a lot of resources and a big kind of deal for what may ultimately end up being potentially a pretty small number of people who come forward to make those claims. And so from an administration of justice perspective, like we're trying to get a better handle. We don't have very good data on this in the system. But these kinds of cases help us get a bit more of a grasp on that too, and try to align the incentives incentives now, it's on the back end of things, but try to align what the plaintiff's class counsel compensation might be a bit better with how many people their case actually compensates, because having a humongous fund, humongous first bucket that anyone can claim from, it looks like, there's $20 million that got this, but if it got distributed between 5 people, that's not very good access to justice. So maybe you have pot 1 that's $1 million, and then if you have all these people come forward, we'll pay up to 20 million. And then the plaintiff's fees can be sort of tailored to one of those buckets. And I think from the court's perspective, there's something helpful there and may assist in questions that the court may have, and they do sometimes, about what is this accomplishing, and especially on the fees. So I think plaintiff counsel are certainly thinking about that, and you can use that to your advantage in the negotiation too, because they have to justify in the end. So that can help.
Anything else?
No, just thank you so much for
Okay.
today. Took time out of their days to.
I don't know.
Oh, thank
Sophie
you. And I
might
know
know.
we have cocktails.
Yeah.
Sophie, are they coming in here? Or
So they'll be in the room
we're
just
gonna move
to.
next door. For
Okay.
anybody. So please do join us for cocktails.
Yeah,
And, thank you all.
Oh, if I may, actually, just before, as we're all kind of wrapping up and picking up our bags, I just wanted to say also that, sometimes these issues can really have a specific kind of angle based on your particular industry, based on kinds of cases that you are really dealing with and seeing or kind of concerned about coming potentially down the line. And so if it would be useful to have a presentation like this, but really tailored to your area of business, to your industry, to a particular kind of class action, we're very happy to come and do that for you at your business or, in whatever sort of context or forum might be helpful. So if you're listening to this thinking, oh, I'd like to know a bit more about this, particularly in this context, we're very happy to have that conversation and to do a formal or informal presentation. So just wanted to put that out there as something you might keep in mind. And with that, cocktails, and we're happy to answer more questions. I was also a bit worried when I didn't see